Bill is nothing more than the latest in a long line of dog whistle attempts to make the government, the National Party and its ACT Party fellow traveller over there seem tough on crime. Sir, this House should be gravely concerned that some of its members would come in here and propose legislation for this reason without any regard for its practical implications. They would place political image above fairness, above the value our society places on the civic duty of voting, above the effectiveness of our electoral role, and above prisoners' reintegration into society upon release in ways that would be impractical to implement for all the reasons that Leanne Dalzell set out in her very fine contribution in this debate. Sir, as well as being completely impracticable, the Attorney-General has notified the House that the Electoral Disqualification of Convicted Prisoners Amendment Bill is unjustifiable because it's inconsistent with the electoral rights affirmed by Section 12 of the New Zealand Bill of Rights Act 1990. And unlike some of the members who are interjecting opposite, I think it should be a matter for serious concern when this House receives a report of inconsistency from the Attorney-General. Because Mr Quinn doesn't clearly know what the process is relating to these reports, I'm going to explain what it is. The Crown Law Office looks at the legislation. It looks at overseas cases. It looks at comparable provisions in overseas and international agreements and in legislation to consider whether or not other courts or other international tribunals have considered whether or not similar provisions are consistent or not with fundamental rights and freedoms. Let's have a look at what the advice that this House has received on that point is. As far as a blanket ban on prisoner voting is concerned, it breaches the New Zealand Bill of Rights Act, sir, because it's inconsistent with the International Covenant on Civil and Political Rights, the High Court decision in Re Bennett, decisions of the Supreme Court of Canada and the European Court of Human Rights. Now, sir, the New Zealand Bill of Rights Act inconsistencies are justified under the bill where the provision serves an important and significant objective and where there is a rational and proportionate connection between the provision and the said objective. Well, the stated objective of this bill is to disenfranchise the most serious offenders. The Attorney-General doesn't express an opinion on whether or not this is an important and significant objective, but regardless of this, he concludes that the objective to disenfranchise the most serious offenders is not rationally linked to the blanket ban on prisoner voting. And there are three reasons for this, sir, that it's worth having in the record of the House. First, not every person serving a sentence of imprisonment is necessarily a serious offender, and people who are not serious offenders will be disenfranchised. Mr Garrett knows better than the Solicitor General on this point by his interjections, but that is the advice on the record from the Attorney. Second, and the example given is a fine defaulter who may be imprisoned but hardly qualifies as a serious offender. Secondly, sir, and the second reason, there's an irrational inconsistency created where mentally impaired prisoners who are detained in a hospital or secure facility for less than 3 years can vote, while all prisoners serving sentences of less than 3 years in prisons cannot vote. Currently, both groups are treated the same. Nothing in this bill to deal with that issue. And thirdly and finally, sir, the blanket ban on prisoner voting is both under and over-inclusive. It's under-inclusive in that a prisoner convicted of a serious violent offence who serves 2.5 years in prison between general elections can vote. And it's over-inclusive in that someone convicted and given a 1-week sentence coinciding with a general election would be prevented from voting. There's a complete inconsistency there that the Select Committee would just be unable to resolve. Sir, this bill has no intention but to make the government look tough on crime, but in doing so, it's proposing impractical changes. If the government were really tough on crime, Mr Speaker, it wouldn't be taking police cars off the street, decreasing firearms training for the police, slashing $21 million of funding from the police, and most of all, not coming to this House every day and implementing the sort of outdated economic policies that create inequality and impoverish our communities in such a way that creates crime in the first place. Sir, this is a bad bill, it's window dressing, it's offensive, it won't work, and that's why Labor opposes it.